So when you get arrested or charged with a DUI, there's documentation that goes to the DMV. The DMV is the agency that controls your driver's license. So what happens is they will automatically suspend your license because of the charge of DUI. But there's good news. You can request a hearing. When you request an administrative hearing, they have to prove that there were reasonable grounds to believe that you were driving under the influence. One of the things with that is when you request that hearing, they will continue to let you drive or leave your license in valid status until that hearing. The DMV right now is scheduling hearings a little ways out. So it will preserve your license for a little while, and then we can look at the facts of your case and see if we can fight the administrative suspension that hearing would prevent. When you're charged with a DUI, you have 7 days to request a hearing or your license gets suspended. In that 7 days, you need to send a letter to the DMV. An attorney can often do this for you. And when you're talking to attorneys about handling your DUI in court, ask them about making sure that administrative hearing gets requested as well. Just make sure you move fast because you only have 7 days. Once you request that hearing, your license will stay valid until the hearing. But if you don't request that hearing, your license will be suspended 7 days after the DUI. If you miss your administrative hearing, your license gets suspended. And then you have to jump through all of the bureaucratic hoops to get it back. So you're gonna have to go to the DMV and follow and do what they tell you to. They can have you serve out the suspension period. They can have you get an ignition interlock device, that thing that you blow in when you start your car and that you need to continuously blow in while you're driving to keep it running. They can have you complete classes, pay fines or reinstatement fees, and they can also have you get an SR22. It's a form of insurance that's typically required after you get a DUI. In Nevada, if you get a DUI, they typically will give you a blood or breath test. When they give you a blood or breath test, you'll see what your blood alcohol concentration is. The blood alcohol concentration that's the legal limit is 0.08, meaning that anything that's higher than 0.08 is technically considered a DUI. You can challenge those tests. For example, if you're given a breath test, you can look at whether or not there was anything in the person's mouth before they took the test, whether or not the instrument or the breath machine that they used to give the test had been taken care of properly, whether or not they waited the proper amount of time between tests, whether or not it's reading accurately at the time of the testing. There's several ways to look at that instrument, as well as looking at the officer who's administering the test. Is he trained to administer the test? Does he have the proper certifications? And is he doing what he's supposed to do while he's administering that test to you in your case? We can also challenge blood tests. Blood tests are different because you can challenge the time that the blood was drawn. Did they use an alcohol-based swab? Or did they use one that was approved for a blood alcohol test? We can also look at the phlebotomist who drew the blood. And then we can challenge the mass spectrometer gas chromatograph. That's the big word for the device that they use to test and see what your blood alcohol concentration is. Regardless of what test they give you, there is a standard of deviation. So there is a little bit of wiggle room in that reading. So we really need to look at that and see whether or not you are actually driving under the influence. If you're charged with a DUI, it's really important that you get legal help right away so that you don't miss that administrative hearing request window of 7 days, and also to make sure you maintain all of the defenses that you have to fight that charge.